Sa panahon ng mabilis na impormasyon at kaliwat kanang balita, kailangan mo ng isang channel na mapagkakatiwalaan, diretsyo at para sa bayan. Ito ang Balitang Pambansa, ang iyong bagong tahanan ng mainit na issue, tunay na impormasyon at mga balitang hindi mo dapat palampasin. Mula sa mga trending na kaganapan sa social media hanggang sa mga seryosong isyong pambansa. Bantay kami sa bawat sulok ng bansa para sa iyo. Hindi lang basta chismis, kundi validated news, mga impormasyon na may batayan at mga kwento ng tunay na buhay Pilipino. At kung gusto mong laging nauuna sa kaalaman, huwag kalimutang mag-like, mag-share at higit sa lahat, mag-subscribe. Dahil sa Balitang Pambansa, balita mo, boses mo, bayan natin ito.
Senado. Gang! Grabe. Hindi ho nito mga kababayan.
Thank you, Mr.
Malupit
President.
ito,
With the permission of the proponent, Senator Marcoleta, I would like to
Yes, Mr. President.
make a few observations and then perhaps ask His Honor's opinion on these matters.
Please.
Thank you. So, Mr. President, I'm reading directly from the case Duterte versus House of Representatives. Page 95. It states, the subsequent filing of the articles of impeachment under Article 11, Section 3.4 against Vice President Sara Z. Duterte and its transmittal by the House of Representatives to the Senate of the 19th Congress is considered to be a separate and distinct mode of initiating the impeachment process. The articles of impeachment are declared barred by Article 11, Section 3.5 of the Constitution. Likewise, they are unconstitutional and are deemed null and void ab initio. Consequently, the Senate did not acquire jurisdiction to constitute itself into an impeachment court. This decision is immediately executory. It shall be deemed served on petitioner and release upon publication in the Supreme Court website and receipt of the parties of their digital copy in accordance with AM number 250516 SC or the guidelines on the transition to electronic filing in the Supreme Court. So, I read this into the record, Mr. President, because I'd like to emphasize a few key phrases. The Senate did not acquire jurisdiction to constitute itself into an impeachment court. I'll start with that one, and then the second one is this decision is immediately executory. So, pag sinabing the Senate did not acquire jurisdiction to constitute itself into an impeachment court, and yet the fact remains that we did constitute ourselves into an impeachment court, then what are we supposed to do? Because the Supreme Court tells us that we did not acquire jurisdiction. As most lawyers, well, all lawyers should know, when the Supreme Court tells another body, usually it's the lower court or sometimes it's a government agency, and the case was by our accepted rules elevated to the Supreme Court. They tell them you have no jurisdiction. The only thing you do is, what do they call it? There's a term, you have residual powers. And those residual powers basically simply allow you to dispose of the case as per instructions of the Supreme Court. Is that the understanding of His Honor?
Yes, Mr. President. Actually, residual powers apply also under Section 135. Yun po yung sinasabi ko kanina.
Grabe itong mama na to. Sobrang nabilib ako. Wala akong bulong-bulong to, walang index card to. Nasa gitna ho siya ng plenaryo. Walang bubuyog na ikangan itong si Atty. Rowena Guanzon. Walang bubuyog na paligid-ligid sa kanya. Utak lang ho talaga mga kababayan. Palakpakan natin ito si Senator Rodante Marcoleta, pambihira. Oo, napakahusay talaga ng idol natin. Ibang klase ho.
Hindi ko po sinabi kanina na I am invoking that because the rules of court are there. Hindi po yun. Kasi legislative department po ang sinabi ko doon. Kasi wala pong applicable rules. Pwede po yun, ma'am, Mr. President.
Kasi ang akin po, and I've tried all my life to be a dutiful citizen, and Alan knows I was a good daughter, a better daughter than he was a son, in terms of following our father's rules. Pag sinabing, hindi mo pwedeng gawin yan, wala kang karapatan na gawin yan, hindi ko gagawin yon. At kung ginawa ko yon, babawiin ko. Kasi nga sinabi sa akin na wala akong karapatan na gawin yon. So, yun ho ang iniintindi ko. I am one of 5, tama bang bilang ko, 5 lawyers here in the Senate. And I'm trying to do my job as a senator and as a lawyer. I am trying to listen carefully to our colleagues who have expressed their desire to constitute ourselves as an impeachment court. But I do not know how we can legally do that when the Supreme Court tells us we did not acquire jurisdiction to constitute ourselves into an impeachment court. We did not acquire it then, and we do not acquire it now. So how would we do that? And those of you who've worked with me know how hard I work to find a solution. I bend over backwards, I listen, I redraft everything para masaya tayong lahat. And of course, within the bounds of the law. How do we do that? How?
Mr. President, I think the good senator already provided the answer. By using the Senate's residual power, kung titignan po niyo yung definition ng residual power, hindi po talaga nakasulat yung power per se. Ngunit inherent sa opisina
Ako yun,
yun. Kaya tinawag pong
ko,
residual
kasi nga-
power. Nung sabihin po ng Korte Suprema, this is immediately executory, wala pong ibang departamento, walang ibang opisina ang tinitingnan niya kundi tayo lamang. Kung hindi tayo gagalaw, wala pong iba na gagalaw. At mananatili pong nakahang ang isyong ito, Mr. President.
So, yun yung first point, Mr. President, that I wanted to raise, and thank you for your response, Senator from Tarlac. And then with respect to the second phrase that I wanted to dive into, immediately executory. So sinabi to dun sa desisyon, and then I think the Senate President mentioned it also, that in their press briefing just yesterday, the Supreme Court stated that, to recall, on July 25, 2025, the Supreme Court granted the petition to dismiss the fourth impeachment complaint against Vice President Duterte in a 13-02 decision with the justices present voting unanimously, and Associate Alfred Benjamin Kagiwa inhibiting, and Associate Justice Maria Filomena Singh on leave. The Supreme Court en banc ruled that the impeachment complaint was void for violating the 1-year ban and due process requirements. This decision is immediately executory. Inulit pa nila sa press briefing nila. So sa akin lang po, parang nahihirapan ako as
Kanina pa ho natin hinihintay yun, yung yung statement na yan, no? Inulit pa ho nila.
a lawyer and a lawyer in the Senate to say that they did not intend it to be immediately executory, because they said this knowing that there already was a motion for recon, and knowing that we are going to have this discussion today, because we made this date public, that on this day we will have this discussion. So again, I'm trying hard to see how, other than disposing of the case using our residual powers following the instructions of the Supreme Court, we can further debate this issue. That is my dilemma, dear colleagues, Mr. President.
May I offer an answer, Mr. President?
Of course.
Pasensya na po kayo kung gagamit po ako ng paghahalimbawa. Nung pong kayo po ay medyo bata-bata po, Madam Senator, meron pong lumigaw sigurado sa inyo. Yung
Huwag na
unang
ho
lumigaw
natin
sa inyo
pasukin yung
talagang...
diskusyon na yon. Mahaba ho ito, mas mahaba po sa debate ng impeachment.
Ganito po yun eh. Tinapat nyo talaga. Ayaw nyo magtagal pa yun eh. At tama naman po yung ginawa ninyo. Ipinakita nyo sa kanya, pinaramdam nyo sa kanya talagang wala siyang maasahan kaysa mapagod pa siya.
Sino ho
Pero
yun?
ang sabi niya sa inyo, ang sabi po niya sa inyo, pwede bang ako'y kahit papaano'y dadalaw-dalaw pa rin? Parang nag-MR. Nasa sayo yun, but that will not change my mind. Ganun din po yun eh. Ang Korte Suprema, sa ganitong, Mr. President, the very tenor of the decision, kahit na po sinabi niyang, oh sige, nasa sayo. Formality na lamang po yun, Mr. President. You are a trial lawyer too. Most of us here became trial lawyers. This is our experience. Huwag po nating pahirapan yun. Sana man lang kung ang decision po 8-7. Yun po pwede nating pagtalunan po eh. Wala po talaga eh, Mr. President.
The gentleman may proceed.
Maybe to add to either the enlightenment or additional bewilderment of Senator Pia Cayetano. Yes, the Supreme Court ruled that we did not have jurisdiction. Yes, the Supreme Court ruled that it is immediately executory, but it makes you wonder why the Supreme Court did not issue a writ of injunction. So
Did not, sorry, I didn't hear that. It makes
did
you
not
wonder
issue-
why.
Did not enjoin us, did not issue a writ. It could have, but it did not. So, yeah, your guess is as good as mine, because if they really wanted us to end this, then why didn't they enjoin us?
Just to add to the bewilderment and the enlightenment, what is there to enjoin when we never acquired jurisdiction according to them?
Nako, butata na naman.
What is the pleasure
Itong
of the Honorable Ontiveros?
Boy Pichay.
Thank you, Mr. President.
Sinasabi
Dalawang
natin
dagdag na punto lang para sa diskusyon natin.
Siya pa to.
Precisely
Dumagdag
regarding
pa to.
the immediately executory na kababanggit lang ni Senator Pangilinan at inulit din kanina ng good gentleman from Tarlac at pati ng good gentlewoman from Taguig Pateros, immediately executory. Still, Mr. President, there is no defiance here dahil the ruling, hindi pa rin po final siya. And even if the ruling states that it is immediately executory, at kahit inulit po yon dun sa recent na anunsyo ng Korte Suprema tungkol sa MR, even if the ruling states that it is immediately executory, the court itself in many cases has explained that this does not mean self-executory. Immediately executory does not mean self-executory. Section 1, at ito kaugnay ng kasasabi ni Senator Pangilinan, Section 1, Rule 39 of the 2019 Rules of Court states that execution shall issue as a matter of right on motion. This means that a writ of execution issued upon a motion is necessary for the execution of a decision. At this point, Mr. President, wala pa pong iniuutos ang Korte Suprema sa Senado. And secondly, at this point, Mr. President, bukod pa po kasi sa yung first group of complainants, yung House of Representatives mismo sa pamamagitan ng Solicitor General at yung isang bayan, meron pang isang importanteng entity, institusyon sa ating lipunan na nagsalita tungkol doon sa Supreme Court ruling. At ito po ay isang entity sa mass media, ang ABS-CBN. Meron po silang anunsyo, ABS-CBN news statement on articles cited in the Supreme Court decision on Vice President Sara Duterte's impeachment. At gusto ko lang i-make of record dito, Mr. President. Sabi nila, ABS-CBN News respectfully clarifies that the article cited in the Supreme Court decision on the impeachment of Vice President Sara Duterte did not state that the House of Representatives transmitted the articles of impeachment to the Senate without a plenary vote. The ABS-CBN statement, Mr. President, calls into question the factual premises of the SC decision. Isa po ito sa binabanggit na numerous factual errors. If the very factual premises were wrong, the legal conclusion cannot be relied upon. With due respect, salamat po, Mr. President.
Majority Floor Leader.
Yes, Mr. President, last but not the least is a quick manifestation from the distinguished gentleman from Palawan, Senator Erwin Tulfo. I move that he be recognized, Mr. President.
Senator Erwin Tulfo is recognized. You
Ayun na
may
si
proceed,
Erwin,
sir,
Erwin,
if the
gusto ko marinig ang sasabihin itong mama na to
gentleman will
Okay.
so yield.
Yes, Mr. President.
Ginoong Pangulo, kabilang bagong senador, ako po nais ko pong maliwanagan dahil kanina pa po ako nagugulamihanan sa mga pangyayari. Dahil 3 motion po ang nakasala ngayon, motion to dismiss, motion to table, motion to archive. Yung pagkaintindi ko po ngayong
Ako wala ako dyan, naiintindihan ko usapan eh. Baka kung ano-ano iniisip mo. Yung motion to archive, yun yung motion to dismiss ni Senator Rodante Marcoleta. Pinapalit kasi walang motion to dismiss para walang maraming usapan. Yan naman motion ni Soto, i-table yung motion nitong si Senator Rodante. Kaya, uwi ka na nga sa inyo.
araw, dalawa lang po ang ating pagdidesisyonan.
Nalilito
Kung
ka.
tayo ay i-dismiss na natin ito, o tayo po ay magkakaroon ng trial. At nag-aantay po ang taong bayan. At lumalalim na po ang gabi. Kaya ang tanong ko po ngayon, are we actually going to vote later or sa ilang saglit? At ano po ang ating pagbobotohan, Ginoong Pangulo? Yan lamang po.
To answer the query of the good gentleman, there are only 2 pending motions. The motion to table by the distinguished minority floor leader, which has precedence over the earlier motion of Senator Marcoleta, supposedly to dismiss, but that he acceded to amend it accordingly, and he will state the motion before we put it to a vote after we dispose of the motion of the minority floor leader to table. So dalawa lang po yung pagbobotohan at dahil sabi ng kagalang-galang ng puno mayoriya na kayo na po yung huling magmamanifest, tutungo na po tayo doon.
Maraming salamat po.
Yan,
With that,
butuan
Mr.
na,
President,
butuan na. Nako, yan na.
and no member wishes to interpolate. The minority leader is also seeking the floor.
Ramdam ho kasi ni Soto eh. Ramdam niya. Nararamdaman niya na matatalo
The
The
siya.
minority
recognized, Mr.
leader is
President.
recognized. What is your pleasure, sir?
Thank you, Mr. President. Just one last push, so to speak.
The gentleman may proceed.
Push na. Anak na to. Brad.
We're not
ka.
saying that we
No, talo ka na. Ngayon, di pa kayo mapagkakatiwalaan. Pagka may caucus, wala nang maniniwala sa inyo dyan. Meron na palang napag-usapan sa caucus na pagdidibatihan tapos pagbobotohan. Anak ng toka, bandang huli, nung nag-umpisa na, iba na sinasabi. Ganyan ho ang utak ng mga nakapaligid kay Tambaluslos at kay Marcos Jr. Hindi mo pagkakatiwalaan. Walang isang salita.
defy the Supreme Court
Oh,
decision. We're simply saying, wait. Patience is a virtue. Yung analogy kasi na sa panliligaw, dismiss mo na kagad. Ano? Although merong mga matintimang birheng bumigay, mas magandang
wala, Brad.
na
Hindi kakanay mga patawa mo dito. Hindi makakapalag yung mga bumigay. Balik ka sa school bukol. Bulaga ka na lang.
analogy ito, Mr. President. In a basketball game,
Oh.
crucial, finals, world championship, merong review ng foul ang referee. Review muna. Dahil may
Anong klaseng kabalbalan yan? Meron bang vice president na diyan sa basketball na yan? Anak ng toko, hindi natin pwedeng ihalin tulad. Kung kanina ligawan, pwede. Pero ito basketball, anong review?
foul eh. Ang gusto ng isang team, maglaro pa rin kahit nire-review. It's as simple as that. So, why not listen to the possibility of not dismissing but not accepting to table. And then we can bring it out anytime. Again, dun sa sinasabing Supreme Court has never considered a unanimous vote. It has. And the Supreme Court also spoke. Sabi nila, the immediately executory, they are not considered final until the lapse of the prescribed period without a so and so and so. Supreme Court din mismo may sabi niyan eh. Yun lamang po, hopefully, kung speculation na pinag-uusapan natin, stating that the Supreme Court will not reverse its unanimous decision is also speculative. So, pagbigyan natin to, Mr. President, sumusunod tayo, pero ilagay naman
Botohan, Brad, botohan. Hindi pwede pakiusapan dito. Magbobotohan tayo.
natin sa lugar. Medyo, ang Senado naman dapat itaas natin ang integridad, reputasyon. Hindi tayo, pag sinabi tumalon, tatalon. Pakinggan naman natin muna dahil maraming mali Maraming error ang House. May error din yung Supreme Court decision, obviously.
Teka lang! Ang dami nila sa Korte Suprema, sa tingin niyo ba kung mali sila, hindi nila makikita yon? Anak ng tokwa, wag naman ganyan, bastusan na yan eh. Meron ba silang parliamentary immunity pagka ganito? Kahit na Korte Suprema, kaya nilang bastusin? Pwede ba tong ganito? Hindi nga pala madidisbar kasi hindi abogado. Okay?
So you cannot right a wrong by another wrong. Thank you, Mr. President.
Noted. Senator
Last
Alan.
na, last mo na yan.
President.
Mr. President. Mr. President.
Last mo na yan,
Mr. President,
So, I'm discussing with the minority leader, trying to pursue a wording that will articulate our collective intent of the Senate. May I just mention and have a few, maybe 2 minutes with what Senator Risa, the esteemed senator, said. Yung spirit kasi ng Constitution, once ka lang pwede ma-impeach sa 1 taon. At very clear po, pati po yung esteemed, I do recognize our the former chairman of the COMELEC, who, if he did not qualify me, I would not have become a councilor. Christian Munsod, our esteemed legal luminaries are here po. Alam niyo po, in all the books nakalagay doon, bakit may 1-year ban? Kasi nga, hindi daw dapat guluhin ng guluhin yung impeachable officer all throughout the year. Dapat isa lang. So yung spirit ng decision, nung sinabi ng BARD na, bigyan mo siya hanggang 1 year, hanggang February 6. Pero lumabas tayo sa legal. Ipa-floating muna natin to. I-dribble muna natin. Tignan muna natin. When is the soonest that the Supreme Court can decide? The next 15, 30 days? By September 1, simula na ng budget hearing sa House. By late September, simula na tayo sa Senate. Baha, DepEd, gamot, trabaho, lahat yan, inaasikaso natin. Kung walang choice at isasabay natin impeachment hapon, impeachment umaga, legislation, bakit hindi? Pero hindi ba dapat bigyan din natin ng katahimikan yung ating bansa at least until February 6?
Correct.
Na sinabi na ng Supreme Court, barred, mali ang proseso, tuldukan na rin natin sa Senado. So, ang isa na lang po ang pinag-uusapan natin, which I want to give honor and thank the minority leader na, pero may appeal. So, whether or not the Senate says tuldukan na natin, nandun pa rin sa Supreme Court yung appeal. Would it be acceptable both to Senator Marcoleta and to the minority, what if we word the motion that we move to adhere to the decision of the Supreme Court in Duterte versus, period. Huwag na natin ilagay sa dulo kung dismiss, area. Merely adhering. Kasi nasa decision naman, nasa loob na naman ng decision na void ab initio and executory right away. So I don't know if that's acceptable. No? I'm trying to think of a word. Adhere, even obey kasi baka ma-misinterpret na because some of us say na wala tayong choice to obey, some think na wag tayo subservient, di ba? But adhere might be a good word. Senator Marcoleta, are we getting closer or medyo lumayo?
I think, Mr. President, we're getting closer, except that we should put some operative words there that would indicate the closure of this very issue.
Mr. President, what if it's we move to for the Senate to adhere to the Senate to the Supreme Court decision in Duterte versus House of Representatives, and hereby terminate whatever unless or until certain time na may. Mr. President, may I ask the good sponsor, is it, can we mention the appeal?
I don't think so, Mr. President. I think we can only
Because
adhere.
it's immediately executory.
I think in obedience to the decision of the Supreme Court, the Senate adheres to it and put to rest.
Let me put it another way, Mr. President. If a motion is approved to act upon the decision and to adhere to the decision, am I correct, Mr. President, that that will be the decision, that will be in our journal, and then by operation of administrative process in the Senate, everything that has to do with the impeachment will be sent to the archives?
That is correct, Your Honor. That is the
Yeah, I yield to
administrative procedure
Yes.
that will logically follow.
my colleagues, Mr. President. I'm just trying to
Senator
come up
Zubiri
with
is
a consensus.
recognized.
Mr. President, I think the operative word today, if we do decide to act on the matters, to archive, as the precedents with former Ombudsman Gutierrez and former Chief Justice Davide. My
No,
question is,
former President Estrada.
former President Estrada, my apologies. Today, one of our Senate resolutions was archived. This is resolution number 35. And it's really simple, a simple amendment to the rules. But my question, Mr. President, is nothing can stop us from pulling it out of the archives and taking it over once again in plenary. Is that correct, Mr. President?
That is correct, Your Honor. Besides, although the Supreme Court said that the Senate never acquired jurisdiction and that the articles of impeachment are void, null and void ab initio from the beginning, we cannot deny the fact that the articles of impeachment were in fact sent to the Senate, that the Senate convened and sent out certain orders and summons.
Dito natin napatunayan na magaling talaga itong si Chis Escudero compared to Soto na maging Senate President.
And these are all part of the records. So it's but natural, although it was declared unconstitutional and that the Senate never acquired jurisdiction, for us to still include that as part of the records of the Senate because it is part of the Senate's history.
Yes, and precedence tells us that we have done so in the past.
That is correct, Your Honor.
So, would it be proper to say that it will be archived without prejudice to the decision from the final decision of the Supreme Court from the motion for reconsideration? I mean, it's the same thing, without prejudice. We do that with the bills. We approve it on second reading without prejudice, but each and every one of us here questioning second reading approval, they have 3 days in which we can act upon it.
Well, Your Honor, whether you state that or not, we can bring it out of the archives by a majority vote anyway. So it's
Yes.
at the pleasure. It's with the pleasure of the body if
Yes.
the body will agree to include that phrase or not. But
Thank you
in
for the
relation to
clarity,
Senator
Mr. President.
Cayetano's suggestion, Senator Marcoleta, if we simply vote in your case, not the motion to table, to adhere. Once that decision becomes final, meaning to say after the lapse of the period for a member who voted with the winning side, on the winning side, to seek a reconsideration, the natural effect, without being included in your motion today, would be to archive it. And by virtue of the manifestation of former Senate President Zubiri, if circumstances change, nothing prevents the body, plenary, from making the corresponding motion, putting it to a vote, and reflect the change in circumstances, if any.
That will be acceptable, Mr. President.
Thank you, Your Honor. Senator Soto?
Mr. President,
Ay, teka, ba't nandiyan ka na naman? Akala ko last na yung kanina. Ang bihira.
Somehow parallel to what you're discussing.
Unbelievable.
Perhaps you could consider, no, and I would like to call the attention of the original proponent of this
Unbelievable.
position, Senator Alan Cayetano, who was former Speaker of the House, to adhere to the Supreme Court decision upon its final disposition. In meantime, table or archive upon whatever your pleasure would be. At least, maliwanag sa atin na upon its final disposition, na may motion for reconsideration. We're still giving that chance of a motion for reconsideration.
If I may, Your Honor, if you will indulge me, if I may state the working motion to adhere to the July 25, 2025 decision of the Supreme Court declaring the articles of impeachment null and void ab initio, and that the Senate did not acquire jurisdiction over the same. We can stop there. And then, as I said, after the vote becomes final, on Monday or Tuesday, if no one will seek a reconsideration, to archive it. If there is no change, then it remains in the archives and nothing needs to be done. If the Supreme Court reverses itself, however possible or impossible that may be, then we will entertain a motion to bring it out of the archives. Bring it out of the archives and act accordingly again in obedience to the Supreme Court decision. So,
ang problema, Mr. President, when we say that the Senate has not acquired jurisdiction, ayon tayo sa sinasabi ng Supreme Court decision nilang ito, na maraming nagsasabi na hindi tama.
Hindi. Kayo lang ang nagsasabing hindi tama. Ito talagang si School Bukol, oh. Ibabalik kita sa One Ball University pag ako nagalit mo. Ibabalik talaga kita sa One Ball University. Anak ng toko, ah. Kayo lang ang nagsasabi. Sambayan ng Pilipino kahit saan tayo magbasa sa social media. Masusundin namin ang desisyon ng Korte Suprema kesa doon sa mga politiko na halal dahil sa pagbabayad sa mga botante. Sila papakinggan namin. Balik kita sa One Ball University.
Dahil tinawag nyo to ng June 9 nag-oath ang Senate President. Nag-oath yung iba ng June 10. Nag-motion. Nag-robe pa nga eh. Hindi naman pwedeng pampelikula lang yun. Pan-TV lang yung robe na yun. You convened. So hindi pwedeng sabihin na Supreme Court that you never acquired jurisdiction. February 5, 4:15 p.m., the Senate President's Office and the Senate Secretary has received the articles of impeachment.
I'm sorry, Minority Leader. Legally, when you say it never...
Sensis, ay Senate President, kalmahan mo lang, huwag masyado soplakin na hindi siya abogado. Hindi kasi marunong eh. Paano ka magsi-Senate President? Talagang itong si School
The Senate
Bukol,
never acquired jurisdiction. It does not deny the fact that we convened. That is a totally different matter. It says that since the articles of impeachment violated the one-year ban, that we never supposedly acquired jurisdiction. Not that we never did when it was not yet barred by the Supreme Court. That factual situation still exists and is part of our records. As I said, that's why the better alternative is to archive it because it was part of what actually happened, transpired, and it's part of the Senate's history. But having said that, without belaboring the point, if agreement cannot be reached, then we can proceed to dispose of the motion of Senator Sotto, our distinguished minority floor leader, to lay the motion of Senator Marcoleta on the table, and depending on the outcome of that vote, should it not be favorable to the movant, then we proceed to act on the motion of Senator Marcoleta. If it is favorable to the movant, the distinguished minority floor leader, then there is no need to proceed with the motion of Senator Marcoleta. Senator Lacson.
Mr. President, we have to determine first if Senator Marcoleta has legal standing in filing his motion to dismiss.
Ano na naman yan legal standing? Ito talaga si...
He will amend this motion later. We will first decide on the motion.
So
to
there's
the table.
amendment to the motion.
Yes. And then let's hear his motion, Your Honor.
Yes.
Ay, nako.
Mr.
Napasabak yung mga galing-galingan sa mainstream media pag nagpapa-interview. Si Soto, si Lacson, si Rizzo, napasabak ko sila kay Senator Dan.
President, the lady from Antique is seeking the floor. I move that he be
Senator Legarda is recognized. What is your pleasure, ma'am?
Thank you, Mr. President. It's been 3 hours and a half with the very enlightening discussions. I just wanted to clarify, and actually, may I convey that there is a sliver of a difference between the two motions, so I wanted to be clarified. The original motion to dismiss, I believe, has been amended based on the discussions to the motion to archive.
Yes.
And the motion to archive, in my understanding, based on all the explanations, would be without prejudice to the reopening of the possibility after the Supreme Court
May masosoplak na naman.
conveys its ruling on the motion for reconsideration, and therefore, in the possibility of the event that it reverses itself, then we would act accordingly.
That is correct.
On the other hand, there is a motion which takes precedence, and that has been the motion of the minority leader to lay on the table the motion. But when you see and interpret the amended motion of the original movement, Senator Marcoleta, and the minority leader's motion, it's similar because it lays on the table, or it somehow just postpones indefinitely until such time that the Supreme Court has decided on the motion for reconsideration. Is there any possibility that we
May I
can
explain the
agree so that we can amend it so that the body can actually vote as one? Because we are not putting it to a permanent halt, because we will be waiting anyway for the motion for reconsideration by the Supreme Court.
Yes, Mr. President.
The ruling on that.
May I have
Yes.
1 minute to explain the difference?
I know that there is,
Yeah.
let me state, I know there is a difference. I was just trying to bridge
Yes.
the difference so that there is no need for a painful vote.
Yes, I will just explain the
yes.
difference so that
Ano painful vote? Ramdam din ako. Ay, nakakatawa. Ito si Legarda, matalino naman to eh. Matalino naman yan. Di ko lang alam kung saan napunta yung utak niya.
Senator
know-
Cayetano is
Yes.
recognized with the permission of Senator Rinto.
Thank you. Mr. President, the reason why I want to explain the difference para malaman natin bakit malapit pero malayo.
Yes, okay.
Because when you laid it on the table, ang ibig sabihin niyan, buhay pa yung impeachment. Samantalang sinabi ng Supreme Court, immediately executory. So pag lay on the table, buhay pa yan, pero mamamatay yan paglabas ng MR. Pag in-archive mo, baliktad. Patay na yan. Kasi sinabi na ng Supreme Court, immediately executory.
Void ab initio.
Pero mabubuhay yan pag binuhay ng Supreme Court. Now, ang ibinigay na po ni Senator Marcoleta sa atin, pumayag na siyang tanggalin yung word na dismiss. Because nga, even I question, we're going to dismiss, wala nga jurisdiction. Although there's a Supreme Court ruling saying na pag wala ka na magawa, walang jurisdiction, i-dismiss. So the proposal, which is accepted by Senator Marcoleta, is that we adhere to the decision and then archive it. So ang natural effect nun, sinunod natin yung Supreme Court na immediately executory. Wala tayong, we cannot say na tama to, malito, malito. You only have two choices. Do you follow the Supreme Court or you don't follow? You cannot say tama to, malito. Diba? So that's I think that's the level of disagreement.
Okay, I
Mr.
take
Chair.
note of that, and I was trying to have a unanimous vote and trying to bridge the two motions, which, based on Rule 31, there is actually no motion to archive, but actually every day we archive in our referral. So because of that practice, then that motion is therefore acceptable. Having said that, Mr. President, let me just summarize what we are voting on. We're actually, and I will just say it, the very, very short dispositive portion of the Supreme Court decision. And this is the article, and I quote it, the articles of impeachment are declared barred by Article 11, Section 3, Paragraph 5 of the Constitution. Likewise, they are unconstitutional and are deemed null and void ab initio. Consequently, the Senate did not acquire jurisdiction to constitute itself into an impeachment court, and this decision is immediately executory. I just wanted to summarize what we've been discussing for 3 hours and a half. And while my attempt to bridge the two similarly worded motions did not succeed, then we will therefore have to put it into a vote. Thank you, Mr.
Majority
President.
Thank you, Mr. President. Mr. President, I think we heard enough,
Botohan
and
na.
I think it's about time that we dispose the motion of our distinguished minority
Mr. President.
leader
Mr.
to lay
President.
this on the table, Mr. President.
President,
So I
parliamentary
move
inquiry.
for the previous
Parliamentary
motion.
inquiry, Mr. President.